challenges confronting the intellectual property and litigation realms, providing a wealth of knowledge and expertise. My heartfelt congratulations go out to each of you for being integral to this monumental event. Your participation isn't just encouraged, it's indispensable. A special thanks to our esteemed exhibitors and sponsors, including Clarivate, NHB Legal, Rakesh, Kistas, Menteso IP, Cyberlaw, Parent Zoom, and heartfelt appreciation to the Ministry of UAE for their invaluable contributions to the success of the 17th World Litigation Forum and 22nd IIPLA 2024 Dubai. So let's embrace this spirit of interaction, revel in good times, and extract the utmost from this exceptional event. Absorb the experience fully and leave with a renewed and positive perspective on your professional endeavors. Together, let's embark on this enlightening journey, engage in dynamic discussions, and make this conference an unforgettable experience. Welcome to Dubai. Welcome to the 17th World Litigation Forum, and welcome to the 22nd IIPLA 2024 Dubai. Thank you. And let the energy of this incredible gathering propel us to new heights. Ladies and gentlemen, before we proceed, I want to express a deep gratitude to the Ministry of Justice Saudi Arabia for gracing us with their presence today. We are sincerely thankful for their strong participation and unwavering support. Your collaboration adds a valuable dimension to our gathering, and we are truly honored to have you with us. Once again, a heartfelt thank you to Ministry of Justice Saudi Arabia for joining hands with us in making this event more exceptional. Let's continue this journey of knowledge and collaboration with renewed vigor. Now, without further ado, let's transition into the first session where we'll explore the ever-evolving terrain of the legal profession. The session one is a changing landscape of legal profession. Our esteemed panel, comprised of distinguished experts from across the globe, is set to reveal the profound impact of legal tech, big data, and virtual courts on the legal landscape. Join us as we delve into the transformative forces reshaping the future of lawyers. Fasten your seatbelts as we embark on a journey through the changing currents of the legal profession. The panelists of the session one are Hossam Zakaria, CEO and founder of SZ Legal UAE. A big round of applause for Hossam Zakaria. And the second panelist is Julius Handler. He's the associate with Morrison Foster London. Julius, if you can join us on the stage, please. And the third panelist is Dr. Amir Tabara. He's international arbitration expert in academic and dispute resolution lawyer, University of Birmingham, UAE. Please join us. Farooq Akhte, the managing partner, Akhte Law Firm, Turkey. Please join. Dana Hamaide, corporate legal counsel, Sharp Consumer Electronics, UAE. And last but not the least, Ekta Rai, advocate from India. Please join us. I'll manage that one. Now, I request our moderator, Julius, to take over the session, please. Julius. What time? All right, so together with this, Julius, just a quick note. So, sorry?
Shall I speak from the seat, or would you like me to speak?
Whatever way you're comfortable. Yeah, okay. So together with this, we have a breakout session in another room that is specifically dedicated for the intellectual property. If you're interested in joining the intellectual property session, please join the other room.
IP track people, please follow me.
Good morning, everyone. It's great to be here in Dubai discussing how legal tech, big data, and virtual courts are shaping the future of lawyers. Obviously, a very interesting topic. It touches every single one of us here, and we all have a perspective we can bring. And it'll be great to have audience questions at the end. We'll kick off by just briefly introducing ourselves. I'll go first. My name is Julius Handler. I am an associate at US law firm Morrison Forster's London office. My practice covers a broad range of contentious matters, litigation, arbitration, but also white-collar crime. And I personally use legal tech every day in litigation to help drive efficiency. During the pandemic, I was involved in virtual courts, and I would like to think I have a future as a lawyer. So all three components of this topic today are of great interest to my practice.
So thank you. My name is Faruk Aktay. I'm based in Istanbul, Turkey. I have my own law firm specialized in cross-border transactions and litigation. I'm qualified as a New York bar member and as a solicitor in England and Wales, which allows me to do so many cross-border stuff. I represented different Gulf-based institutional investors for the new technologies as well, for Turkey operations or for regional operations. So I see that a wave of new technologies are coming. That's what has been discussed at the New York Bar Association. I'm also an executive committee member of the New York Bar Association International Section. So I would be happy to, share my comments on it. Thank you.
Hi guys, thank you, colleague. My name is Hussam Zakaria. I'm the CEO and founder of HZ Legal Consultations with the experience of 20 years in the countries. I'm already based in UAE, in Dubai exactly. I'm a specialist in dispute resolutions, and I hope you have a wonderful session with us. Thank you.
Thank you. Good morning. My name is Amir Tabbara. I'm an assistant professor of international dispute resolution at Birmingham University. I'm also a certified independent arbitrator. So I teach international dispute resolution, construction law. I'm also a lawyer, and I hope we're going to have a fruitful session. Thank you.
Hi, my name is Ekta. I am from India. I'm an independent advocate specializing in ADR and primarily corporate litigation. And like Julius said, that now post-pandemic, AI has come to stay. So still learning the nuances of the field, but I hope I'm able to offer some insights in the current practice in India. Thank you.
Thanks very much, Paul. And I suppose we should start by defining what we mean by legal tech, big data, and virtual courts. All have a similarity in that they're very much futuristic and forward-looking. And I'd like to open it up to the panel to see what, for example, Amir, what do you see as the main attractions and developments, the opportunities of legal tech, big data, virtual courts, and what do you take this to mean?
Yes, actually, as an expert in international dispute resolution, I think that arbitration not recently, like for the past 10 years, maybe has suffered some deficiency. When we talk about arbitration, we always talk about efficiency, about cost effectiveness. But when I've been working on some arbitration, especially like complex cases, I noted that arbitration is no more efficient and is no more cost effective, and arbitration proceedings sometimes might take a lot of time, sometimes maybe more than litigating before state courts. So I think that the use of artificial intelligence as technology will bring back, this is my personal opinion, the efficiency and the cost effectiveness of arbitration. And as a professor and as a practitioner of international arbitration, I start noticing that the use of artificial intelligence and technology is becoming really important. Just to start with a simple example, like virtual arbitration or online arbitration, which have been developed especially after the COVID, is the simplest example of how technology and artificial intelligence are affecting international arbitration. So today it's possible to have an online arbitration without the physical attendance of the parties. with the arbitrator delivering an electronic award, etc. So these are some. This is for me the clearest example of how technology and artificial intelligence is helping and will reshape actually international arbitration. Yeah.
It's really interesting. I certainly found during the pandemic it was a totally new way of managing and conducting disputes. We had to have virtual courts, we all had to dial in, and even different members of the team couldn't be together. And that presented some real challenges, but as you say, also some real opportunities, because even now, post-pandemic, we are conducting hearings and trials in a hybrid way, and it's driving a huge amount of efficiencies. It allows the team to collaborate much more meaningfully during a hearing, because you might be because you're only connected with the judge via a video link, for example. So you can have all these conversations, involve the client in a way you wouldn't be able to do if you were in an in-person hearing. So it is enormously helpful. Instead of a physical trial bundle, now we have much more commonly an electronic trial bundle, which is much cheaper, much more user-friendly, and much more efficient in conducting hearings. Hector, in your introduction, you mentioned AI. What are your takes on this specifically?
So if I'm being absolutely honest, I am still struggling with incorporating it in my practice, because my understanding is there are certain aspects of law that can be incorporated with AI, because with things like Bard, Google Bard, ChatGPT, you can explore the possibilities of creating drafts. You can upload a template, give it certain specifications, certain prompts, it'll derive the data for you and give you the output which you want, and you can eventually fine-tune it. But I've experienced that in litigation. While we can put certain administrative aspects into AI, integrate AI into certain like case management systems and things like this, I think the strategizing, the arguments, they still can't be adopted. As yet, they still can't be adopted in the AI. For that, you still need to know how to strategize. So while I think AI is here to stay, and we should, like people say that AI will take over the jobs, and we have read it too often now that it's not AI that will take over the job, it's people who know how to use AI that will take over the job. So it's best to stay, on with the trend. However, I do believe that even while using AI, you can't sit back and assume that it can take over your tasks without an input from your end. If you have to draft a contract, you should know how to draft a contract before you can give ChatGPT an idea of what you're looking for. So I still think knowledge is irreplaceable, but AI is here to stay, and integrating it. I think the real question we should ask is, to what extent are we willing to integrate it in our system, and especially when it comes to litigation, because back in corporate, it is fully integrated. Research is integrated. But when you come down to the practice, to the courts, when you're sitting and when you're arguing the matter, AI is not going to assist. That's the current opinion that I hold.
And Hossam, I know that you have specific views on the side effects of AI. Could you take us through those?
As a growing up from a background of a family from law, a couple of days ago, my father was reminding me in 1996, he was reading a news saying there will be a communication between the client and their lawyers by emails. In that time, he was surprising how it will be happening in that days. So it was strange for him to see an AI now, which is generating most of or integrating or interfering in all the lawyer jobs nowadays. See, as AI affects in the legal aspects and the legal technologies, I would love to open a different side of different aspect of legals, which is the side effect or the negativity effect of AI. As we know that AI is a human description and data being entry, but what if AI being accused by somehow in different way in negativities, similar like an incident happened in California in last January. With a company named Don't Pay owner, he gave a whispering machine for a self-defendant client to defend in front lawyer with the same whispering machine and hands-free. And that was happening depending on a technology which he been using it, that it will be listening to the whatever the defendant or whatever the accusation happening in the court, and it will be programming it and write the defendant on the program where he have to repeat it in front of that. Of course, the California was looking to it as a violating of practice of law. That's why they were mostly going to sue him in that. So it could be that considering as a self-defense or as a breach of law, part of it. For example, there is another incident, a developer asked AI or ChatGPT, one of the developed part of ChatGPT, to create or to write a Chrome extension in 10 hours, and he sold it for thousands. The conflict, legal conflict, which been happening in that time was who owned this extension which been created by AI, whether the developer himself or the programmer or the coding guy or the client who signed such things like that. Similar like that, AI even, we all are here because as lawyers to think about why we as a law are so struggle in different and opposite in all other fields to use AI in our field. That's it.
It's really interesting. And I think from my perspective, the risks that you touch on fall into a number of categories. I think first there are ethical risks. And we've seen in the use of AI, there's a risk of discrimination based on past data and how that might affect decision making. And I think the principle, if you put garbage in to an algorithm, garbage comes out. Second, there are interesting examples of how AI has been inaccurate, causing hallucinations and instances where an AI and predictive text generated made-up false case law. The extent to which an inaccuracy of tech is a new thing, I think is actually quite limited. In all our practices, ever since kind of the dawn of the internet, we've had to use our own judgment and discretion to make sure that we take a critical eye as to what we're looking at. I think third, there are data protection concerns. Personal data can be stored on, for example, blockchain. There's data concerns in using AI and what you feed into it. And this also ties into another risk, which is confidentiality. If you use, for example, ChatGPT, what are you putting into it? Are you putting in client-sensitive data or information? Where's that going? And then I think, finally, there are risks in terms of how we use it. One's discretion and judgment in how we rely on it. How transparent, how explainable, how accountable is using AI tools. To some, it might seem like a real black box. We might over-rely on these tools and lack a contextual understanding. So I think my takeaway on how to mitigate these risks is to use judgment, to have guidelines as to how to use it, and to interrogate it, not to over-rely on it, and be careful on what data you put into it. Farooq, we'd be really interested to hear your perspective on these topics.
Thank you. I mean, all the contributions so far, I mean, have been so valuable. Maybe I can start with one of the recent memories that I have, like as part of during the pandemic. So we definitely see that some of the new technologies allows us to do business in a more efficient way to conduct this legal profession. For instance, like I was representing a client in Turkey, they were exporters of, importers of some specialized steel products. So, and the customer, the client was a British producer, for instance. During the pandemic, for instance, on behalf of Turkish clients, thanks to the virtual courtrooms and the teleconferencing, etc., we managed to, without even traveling to the UK, I mean, we managed to litigate the case and successfully settled the matter during the pandemic. So, I mean, this proved that, I mean, there are definitely new technologies will be coming, and my impression is that although we have been discussing the artificial intelligence and how it may really change the way we do the business, but I think from the way we work, I think there are more technologies are coming. So I believe that, I mean, we will be providing our legal profession wherever and possible, thanks to the virtual platforms. And I see that, for instance, these video conferencing, etc., have been helping us a lot. For instance, after the pandemic, and I believe, like, I mean, different countries will have different degrees of conducting this profession, virtually or physically. So it will be up to the governments to digitally transform the services that the lawyers can provide in their own country. For instance, after the recent changes, and as I really promoted that virtual courtrooms, etc. For instance, in Turkey, we also adopted a similar virtual courtrooms in 2022, and last year we managed to put it in every courtroom where the judge can, thanks to the cameras and the big TV screens installed into each and every courtroom all over the country. Now I see that in the new phase, for instance, a mobile application has also been created by the Ministry of Justice, so that, I mean, as a lawyer, if you want to litigate and if you have an excuse to go to the courtroom, then your pleading or request for taking part in the courtroom in a virtual way made it possible. So you just, open up your mobile application and turn the camera on and say hi to the judge, and you take your role as the either defendant or the claimant's counsel. So saying that, my impression is that this is what has been discussed in New York also recently last year. I think virtual services like Meta will be offering us to conduct this business even without having offices. So I see that there are technologies like that coming, but to what extent we will be adapting and welcoming it will be up to us. I think this brings us to, I can also comment on Hassan's point. I think whatever the new technology is, for instance, there have been so many new technologies which were coming. So initially it was with the contract drafting, and then some legal due diligences can be made possible through the preliminary versions of the, let's say, artificial intelligence technologies. And one interesting, striking example was that in 2017, when JP Morgan in New York adopted its own artificial intelligence, over the same year, they have saved 306,000 lawyer hours, and instead of paying it to the lawyers, then they saved it as the most profitable investment bank in the world. So they paid less to their lawyers. So I mean, this, I think, shows that, like, who owns the technology, it definitely matters. If the client owns these technologies, it will be in the loss of our profession. But if the bar associations or the lawyers themselves own it, or some technology companies own it, but put it into the service of the lawyers as a service, like SaaS models, like, I mean, service with paying regular service fees, then it will be more egalitarian, and it will not be in the loss of the lawyers. So coming to that point, maybe I think my last comment on this one, eventually, like, I mean, our legal fees should also adapt as well. Like, I mean, how we will charge the clients, I think, will matter. So where the new technologies are used, I believe that the current highly discussed, like already discussed, hourly rate systems will no longer exist, but the value addition to the project will become the norm. So I mean, the client will come to you, they will need your services. You may want to put the AI into your services or not. I mean, regardless of that one, I think whatever you will be charging to your client will be more based on value addition, because we may be, I think my expectation is that we will be working less and earning more based on this one. So, I mean, these are my comments. Thank you.
Thank you. That's really interesting. Picking up Amma specifically on the arbitration context, I know you've been looking into different provisions depending on which arbitral institution you're in front of, the role of legal tech specifically in arbitration. Could you shed a bit more light on that?
Yes, of course. Actually, I think we need also to draw a distinction between the different software that we use, I mean, whether as a transactional lawyer or arbitration. So, for instance, in the context of arbitration, I think that artificial intelligence is playing a very important role in terms of ensuring the efficiency and reducing the cost. For instance, we can mention some system which help the lawyers to draft a valid arbitration clause. I mean, everyone thinks that pathological arbitration clauses today are no more existent. But when I review some contracts, even like high-stake contracts, I see that some arbitration clauses are invalid or pathological because they don't meet the requirement as per the law. So today it's possible through a certain artificial intelligence application to have our arbitration clause reviewed and analysis in order to be able, in order to be conform and not pathological. Okay. For instance, the American Arbitration Association has an online tool which is a clause builder, which help parties, for instance, to draft a valid arbitration clause. Also, the use of artificial intelligence is now very important in the selection of arbitrator. It's very hard today to select an arbitrator because when we want to select an arbitrator, we take into account a lot of elements. We take into account whether this arbitrator is familiar with this substantive law, whether this arbitrator is expert in this field. So today we have some application and arbitration that help the parties to select the appropriate arbitrator by reference to a certain number of elements, such as the language, the availability, the publication of this article. So this artificial intelligence software, from my point of view, they don't raise a lot of challenges and concerns when we are talking about challenges and concerns regarding the use of artificial intelligence. Same things apply also for e-discovery, which is currently used in international arbitration and which enormously reduce cost associated with the normal discovery procedure. So these are some of the tools that are used by the parties. Also, the arbitrator is able to use some tools in order to make the arbitration proceedings more efficient. For instance, we have the development of tool for planning and scheduling meetings. This is not a specificity for arbitration, but arbitrators use these tools now because when we have different parties located in different countries, it's very hard to, and people working in arbitration might maybe understand what I mean. It's very hard to agree on a convenient time frame for all the parties to meet together with all the time difference. So today we have some application which help the parties and the arbitrator to plan and schedule meeting. Also, we have the development of some application which help to review documents. So if I have, especially for instance in construction dispute, when we have a lot of documents and it's very hard to read all the documents. So today with the existence of this artificial intelligence application which help to review documents, this is also used especially by international law firm, and I mean, it ensures the effectiveness of arbitration. Now, it might cause some challenges. Maybe later on we can discuss it. But one of the challenges, for instance, for the using of this tool is the role of junior lawyer in law firm, because especially in arbitration, junior lawyer in arbitration used to perform legal research, to analyze documents. With the existence of these tools, I'm wondering what would be the consequences for young lawyer or junior lawyers while they are being competing with this kind of application.
And I think there's a really interesting point you pick up on as to how much legal tech AI, all the advancements we enjoy and make our lives easier, actually, do they make us worse lawyers? Are we losing valuable skills that would be gained by having to trawl through legal precedents, rules, and instead having an immediate answer that can currently be provided by ChatGPT? When I started practice, admittedly, not a hugely long time ago, I would spend hours and hours into the early morning looking at legal precedents, conducting research. Now, when we have the likes of an AI tool called Harvey, which is basically ChatGPT for law, you put in your question and out pops an answer. It saves time, it saves money for the client, subject to the costs of using these technologies. And there's a very interesting question that Farouk pointed out, which is who owns the software, how is this charged, what's going to happen to the billable hour. But to my mind, a lot of being able to spot issues and scope out a topic comes from being able to start very broad, think of all the issues, and then drilling down, having perhaps ticked off a few of the different points. And I query whether that is now lost because legal research, for example, is so much easier. I'm wondering, Hector, you're nodding your head. What are your views on legal development, building your skills as a lawyer, and the impact that these legal technologies have on that?
I actually agree. In fact, had you not picked it up, I would have said it. Mr. Akhte also was very right in the fact that eventually the practice of lawyers is taking a hit. But I think, and I'd like to be optimistic on this side, that when AI challenges everything, I think people are going to come to the lawyers. What are the regulations? How do we do it right? So the first thing first, I think the common challenges for everybody here was the regulation of AI, to what extent you should be integrating it, and when you are, the challenges of copyright, who owns it. Like and I think personally, I think it doesn't matter who is actually owning it, whether it's the end consumer or even the lawyers or whoever is owning it. I do believe that the effect is more or less the same. What is really interesting, the good news for our generation of lawyers, and probably a challenging issue for the young lawyers, is that the young lawyers will come when the era of ChatGPT exists. For them, the efforts are significantly reduced, the patience goes significantly down, and I don't think litigation or law as such is a field which can truly sustain without endless patience. The research, the strategizing, and I keep harping back to strategizing because I feel as a litigator, that is an irreplaceable skill. And an AI at the end of the day is an artificial intelligence. Anything that you can do thinking on your feet, standing in the court, an AI will not provide you. It will not predict human behavior to that extent. We are still humans, we are still unpredictable, which is a good thing for us. We still are in the game. The new generation will face that challenge. Like you said, you get up in the morning, you go through research. Today, you can put in a question, get an answer, because you know what to look for. You know exactly what, and because you have a back experience of what precedents are, if something is off, you can point it out. No, I think maybe we can look for that. The new generation lawyers are just going to fill in the data, get the result. They will not challenge it. The usage of brain will go significantly down. That is why I think we are afraid that AI will take over, because if we start relying on AI for almost everything without using our brains, I think instead of being grateful, we'll be grapefruits, and nobody will be, the wiser to tell the difference. So I do think that would be good for us, not so good for the new generation, but we make money where we can.
Hassan.
So I hope we didn't feel like I am the negative vibe here for AI. I'm so sorry for that, but let me comment on some points. As Julia spoke already, Harvey is similar like a spell book. It's AI programming where you are connecting it with your data and all your contracts and precedents, previous laws, and it's creating you a summary of what you have to do it in many hours or many days in a couple of hours only. Yes, it's helping us to develop the legal tech in legal ways, which can also, as analysis been said recently, in 2040, hundreds of jobs of lawyer will be disappeared, as Amir said, and from the junior lawyers, paralegal, receptionist, things like that. But what they are not capable to do, they cannot build a client relationship, right? They cannot also exercising judgment in the complex issues. Also, they cannot inform us which question you should answer in the first. Also, they cannot give you a set of layers of concept which you said for the deponent, so you can give an idea what you want to mention or what you want to expose, right? It's not an easy. So that is the difference. Also, there is another program which is co-counsel, which has been mentioned by one of the senators in White House, which working in the co-counsel. He mentioned it in correct way. He said it's a chat GPT, which we take it from primary school to standard school, but it's in the school. We didn't reach yet to the university. It's not being graduated yet. It still have this effect. Also, one of the cases also, which we heard about it, I don't know if it's exposed yet or not, but as Farouk was mentioning, to open a video and represent a client, there was an incident which happened with a deep fake videos as someone act as a client defendant, and he wasn't a client defendant. He wasn't a lawyer. Also, there is another programming which using, for example, recognize your signature and the checks, which been worrying thing for the banks nowadays. So even with AIs, I am not opponent of it. I'm not against on it. But still, as we mentioned, and all my colleagues said, if it's not being regulated, being in the surface, how to deal with it, and how to know all the data entry from beginning until the outcomes, it will still a challenge for all of us to be facing or to handle with it.
And I think the point about how AI is regulated varies on jurisdiction. So, for example, in the UK, we do not have an AI Act. We don't have a single regulator that is going to look at AI, and the way that the UK plans to do it and will be doing it is for each individual regulator, so the Financial Conduct Authority or the Competition and Markets Authority, each will have remit and jurisdiction over regulating the use of AI within their competence. I think there's a clear benefit to this, which is that the regulators with the respective jurisdiction and industry expertise and market knowledge are regulating and making provisions for AI. But an interesting question, and I think it's too early to provide an answer, is the extent to which we're going to lose consistency in approach. If you compare that to the EU AI Act, which is, I think, one of the first, if not the first, large, broad legislation addressing the use of AI, categorizing different penalties based on harm. That's a very different approach. And if we look at the US, that's a more principles-based approach. And interestingly, the US have, although the commercial market is at the forefront of this, in terms of regulating and legislating, seems to be on the back foot and kind of taking a wait-and-see type approach. Clear divergence between the proactivity of the EU versus the US. I was wondering...
I just want to interrupt you for last question. It's an open question. As we know, the AI as enforcement learning machine, AI, ethic. So what if, as we saw in, sorry to mention it, but we saw it with the great actor of Will Smith in iRobot. What if AI fight the three rules which they are built on and make the third one the first one? As we know, AI always built on, first, obey for humanity, not to hurt humanity. Third thing is to fight for existing. So if it's fight until the third one become the first, what will happen in that time as AI? You know, especially in laws, how it will affect. Just that's all.
No, it's an interesting question, and I think one can get very, very futuristic and Isaac Asimov about all of this. And I think, I suppose, on a more practical level, and the topic does talk about legal tech and big data, although there seem to be a lot of very scary things about AI and questions as to how it's going to affect our practice. There's some quite interesting tools currently used in practice. I'm sure a lot of us use these in the context of e-discovery. How do you sift through 1 million documents with clever search terms? When I started practice, it was the case that you would come up with search terms to distill a massive data set into a smaller data set, and you would review them. That would take a lot of time, it would cost a lot of money. With the use of legal tech, predictive coding, technology-assisted review, you are reviewing, and there's machine learning. So there's constant feedback based on how you categorize a document as relevant to certain issues in a litigation. And it allows the machine, the platform, to rank the documents based on their relevance, and allows you, if you start with 1 million documents, you then apply your search terms, you might have 10,000 documents, you start reviewing, and the machine learning picks up what the relevant documents are and then ranks them. So you get the most relevant documents first, and what you now get in common law and UK disclosure exercises is that after you've hit the first 60% of relevant documents, and it soon becomes clear that you've kind of gone through all the relevant documents, you can stop, which is totally defensible. The courts are happy with it, the client is really pleased with it, and the opposing side doesn't matter either, because they don't want to get 4,000 irrelevant documents that they have to sift through. I suppose if we were having this conference 15 years ago, the idea that you wouldn't review every single document, or you would trust in a machine to allow you to stop reviewing 40% of them, would be considered heresy. But here we have the use of a simple, non-judgmental tool that allows you to deal and sift with evidence much more easily. And in a world where we have ever-expanding data, sources of data, it's not just documents now, it's not just emails now, it's WhatsApps, it's Teams messages, it's kind of scans of hard copy documents, it's PST mailbox files, all this different type of metadata, and I think it is it's a necessity, something which we use every day, but I think something that we should be aware of as allowing litigation to be much more manageable, efficient, and ultimately cheaper and proportional. Farouk, do you have any kind of comments or kind of observations on points we've picked up so far?
Sure. It was another, valuable comments, round of, general comments. So I think I have two more additions to this discussion. Like one of them is that I definitely agree. AI and the new technologies, starting from the drafting of basic templates for contracts and then continuing with the drafting of legal due diligence, we have made so far so many progresses. And on the other hand, the new artificial intelligence also offers us this discussion. To what extent the artificial intelligence services can draft the petition and then find discoveries, etc. I think there have been new technologies coming which will be making our life more efficient. With that efficiency, there will be discussions in our profession like this. But I think another important wave of change is coming, and this I believe this is a source of opportunity for the law firms, especially, is the compliance-related work and how the compliance is conducted. Because, what so far we have witnessed is, compliance is, there's a term ex ante, ex post. So, the compliance works are usually conducted ex post. So, the companies usually hire lawyers and they ask if their C-level managers, for instance, have exchanged any antitrust violation emails with their counterparties, rivals, etc. So in case of any investigation, the company wants to secure themselves and find internal investigations before it was detected by the regulatory bodies during an investigation. So I think this will change and should change. So the law firms so far, with the new technologies, especially the big law firms like global ones, try to present their clients that there is indeed a competition. So the law firms really welcome these new technologies, and they want to show their superiority over their rivals by showing that, you know, our AI is better than their AI type of thing. So I think this competition at the end of the day useless, because from the client perspective, they really care about whether you successfully close the deal or you win the case, etc. So it is just a competition that we make on our own, but in terms of the value that it creates, to what extent it makes life really different for the clients, I don't think so. There is not much difference. So I think the difference will come from the law firm's way of conducting this profession, and then I think the law firms will become more like the consultancy firms going forward. So why I say so? Because, for instance, like we will be not the service providers. I think we will be acting like the more management consultants, where they see an opportunity, then they knock on the door of the client and make some value proposals and come up with business development models and say that, you know, we can provide you this service based on this compliance project, etc. And the firms, I think, just because I think they have limited budgets for their legal costs, but more budgets in the more fashionable, trendy items like digital transformation. So what I observed is that when you approach your client, especially the big global multinational conglomerates, etc., and when you tell them that, you know, I mean, you conduct this compliance work ex post, but why would you try to create a system where your employees can be made sure that, you know, they are acting in compliance? So all these technologies are available for you. So instead of really trying to detect the compliance works, I think what we can do is try to get more share from the digital transformation budgets of the big businesses and say that why don't we provide you consulting about the way you do compliance when even when there is no ongoing investigation, etc. And I see that there are really big workload that may be coming if we change our business model, because in one of the ABA meetings that I regularly attend in springtime in Washington, D.C., where there are more than 3,000 market regulators attend all around the world, I see that, you know, lawyers still struggling to come up with the basic definitions of big data and how it will affect the market power, etc. So different jurisdictions still struggling coming up with a coherent definition of these things. So I think this shows that, I mean, the new technologies are coming, but as lawyers, we are not really fast enough to see the opportunity there and seize it. So we really like all these arguments. And the regulations are also coming with a big lag. I think it take a couple of years for the new businesses to come. So, but to think from this compliance perspective, so new technologies definitely create new services, like the importance of the data protection and all the data protection compliance services that we have put over the last 5 to 6 years. So I think, so if we act quickly and if we try to, you know, make sure that this is a new way of area of compliance where the lawyers should take more active part, I think we will be, you know, coming up with our value proposals and, you know, new business proposals, etc., so that the government, the clients really sees that, you know, we can provide them new services and they really need it. So to come back to the point that I started, I think the digital transformation works, and I was going to say that in those Washington meetings, like, I mean, the FTC, Federal Trade Commission chair, interestingly stated that, she, back in a couple of years ago before the pandemic, devoted more than half of his time with meetings with the IT teams. Because so many things, especially in the antitrust compliance, etc., were evolved around this new technology process. Why? Because they say that their number one problem is the big market e-commerce companies. So e-commerce companies comes up with their own models where they are using it electronically. So where you have an algorithm of a big, let's say, retailer company, let's say Amazon, how you can really make sure, or as a government body, to make sure that this company acts not in violation of these market regulations. So the only way is to, as a regulator, come up with your own digital services or your program, your algorithm, which checks, monitors the algorithm of the competitors in the market. So that type of thing, when you see it from the regulatory body perspective and the need of the new technologies to make sure that the targets are monitored properly, I see that we will be working more and more with the IT teams, and we should really adapt it into our lives, and we should really become part of the another source of income as a consultancy, legal consultancy for the digital transformation project, etc., in cooperation with the IT teams and the company managers. So I see this area will also may bring new services to us. Thank you.
Thanks very much. I'm keen that we end at 10:30, so we can all have our second round of coffees and have time for audience questions. But before that, it would be great to go along the panel, starting with you, Ekta, and working down with some final and brief concluding remarks, impressions, any views or thoughts you have that you haven't covered.
I think everything has been largely covered by everyone on the panel. I would like to, however, comment on what Akhtar just said, especially actually just from the point of view of the Indian practice, because the compliance and all that aspect is already taken care of by the company secretaries in India. Lawyers, as per the bar rules, are not allowed to solicit in any manner. So we'll have to see a look around. But since considering that we are here on the aspect of how AI is impacting the litigation, not the back end and not the compliance aspect of practice, while I understand the necessity of coming in, of taking it in and of integrating it, I am more and more on side of Hussain, on the side that it has more drawbacks if we let it take over. As long as we are regulating it, as long as we are deciding what it does for us, to what extent it does for us, and in what capacity and under what guidelines it is doing things for us, we are still in control. The minute we let it take over, how to deal with the client. If we start asking those questions, which really require an interpersonal skill, which really require the human touch, I think that is when we lose control, and that is when I don't think currently any government is equipped to create a law or to maybe come up with a law that can effectively regulate AI. And the pace at which it's growing, this has to be a matter of concern, not just for the lawyers. I think lawyers, maybe I'm too optimistic, but we never really go out of work. Something will come up. Something will always come up. So that is something that I'll always hold on to. But yes, in terms of policy, because I remember recently I just, while scrolling through LinkedIn, I believe, I saw that, I think it was Brazil, that one of the legislations has been drafted entirely by ChatGPT, and it has been passed by the parliament. That's a scary thing. If that has actually happened, that is a scary thing. A nuanced use of ChatGPT, yes, there are too many inputs that you can do, regulate, and come up with something that is hopefully not copyright infringing. But still, if we are allowing an AI to draft an entire legislation that is affecting humans, maybe we trust it too much, or maybe we are somewhere blurring the lines that should not be blurred, especially in terms of law. We have to, I'd like to believe that we are the, how do you say that? We are the like the border which should not be crossed. So in that case, I'm team you. That absolutely. Thank you.
Thanks so much. Amar, any thoughts, concluding thoughts from you?
Yes, actually, I think, and since I'm talking about arbitration, I think, the use of artificial intelligence is a fact that we are not able to deny in the future, and the use of this application will be more frequent in the future. Even, we didn't discuss this point, but just to share some ideas, even there are some discussion about the possibility to have an artificial intelligence arbitrator, like to have a machine giving a rendering arbitration award. This raises a lot of challenges, but this is also a possibility, and a lot of literature is now dealing with this issue. I agree with the panelists that we don't have a regulatory framework, especially in international arbitration. We are seeing the emergence of some guidelines or soft law regarding the use of technology in international arbitration, because there are a lot of challenges also raised by the use of technology. For instance, what if you have two parties which are not technologically equal? Would the arbitrator force the use of technology or not, for instance? This is one of the issues this is a procedural issue that might be raised in international arbitration proceedings. The second issue that might be raised, what if the arbitral tribunal is not familiar with technology? Would the parties impose on the arbitrator or the arbitral tribunal the use of technology that the arbitrator tribunal is not familiar with? This is also something that needs to be addressed. Also, is there any obligation of disclosure from one of the parties if they have used ChatGPT, for instance, or if they have, or the expert have used for instance, some application to make the calculation? Is there any obligation of disclosure? All these issues are not really yet addressed, and may raise a lot of problems. These problems can be solved actually by just asking the regulator to regulate this procedural issue, or also the arbitration institution by providing some guidelines for the parties. So I think that we are going to live with artificial intelligence. We are not going to deny it. And in order for lawyer to be, especially a dispute resolution lawyer, I think that in order to be able to work in this field, they need to be familiar with this technology. Also for arbitrators, especially arbitrators who are willing to work on high profile cases, they need also to be aware, and they need to be familiar with technology, otherwise parties will not appoint them, because I think that this is now a requirement that an arbitrator will be technologically educated. Otherwise parties will not appoint him. Yeah, so this is in a nutshell.
Brilliant. Hossam, any final concluding thoughts?
A summary of discussion which I had before I entered in the conference, there was a question asked of when anyone joining for a social medias, always we are taking agree for disposing all the data which we are entering. So in AI, if you are using it as a data connection with internet and protection of client securities, what if the client data or the client confidentiality being disposed from a law firm? How the client will be affected on that, and how the data which being exposed will affect him, and if there is a case against him in that ways. So in AI, I'm not against or negativities, not giving any negativities of AI in general, but it's that's our life as a humanity. There is a bad side and good side, but I always, as the lawyers, we always look in the negative effect before the right effects. So how you are looking to that, how you are going to handle that, the protection of data, the client confidentiality, the AI and the IB copyrights, which I mentioned one of the cases which broke already the copyrights of the clients. I'm not against. In the end, a question, a summary question of if AI being used and it's been integrated and implemented very well in a law firm, are we going to reduce our cost? Yeah. Thanks.
Thank you. And Farouk, final concluding thoughts before we open up to the floor?
Thank you so much for this panel. I think it was really, we had a live discussion, and we touched upon almost all important issues. So I'm in general optimistic. So a better future awaits our profession. So we will definitely be, I think we will be working more flexible I think that will be the trend that we will be following. And because the business world and the global business, I think, will keep on becoming more and more global, and there are still more efficiencies in terms of our overall welfare, like global welfare. We need to think about how we make business more easier. So I think as part of this broader perspective, our profession should also adapt new technologies. So, like I said, there will be some virtual offices, virtual courtrooms, and more technologies will come from there. Especially the discussions that you make, like in the arbitration litigation, all the discovery processes, I think, will be transformed. So, in general, I see opportunities, and I think, like I said, digital services in these new technologies can be also interpreted as the digital infrastructure to be provided by the governments. So as the lawyers, we should really, go back to our countries, encourage our governments to really provide those services that we see from other countries, and they should really facilitate it, offer it to us. So with these new technologies, the law firms will, I think, transform their businesses. I think especially the consultancy firm approach and, coming up with the business development opportunities instead of the client waiting for the client come back to us would be an interesting thing, especially to tap into the digital transformation budgets of the big businesses. And the last point is, I think the international arbitration centers should also adopt these technologies, and like the commercial ports providing some handling services, etc. Those kind of services may be offered by the arbitration centers in exchange for some service fees. So I expect that the arbitration centers, like the law firms, may adopt these technologies and may say that, for instance, our discovery tools are better than this arbitration center, so you should really come and use our service, etc. I think we will be seeing new and different ways of competition, so we will see. Thank you so much for today.
Brilliant. Thank you, everyone. Just to tie up some final themes here. So we've touched on a number of issues, legal tech, how it can assist us, ethical considerations in its use, side effects and dangers. What does this mean for the legal profession, for training, development, client service? What does a really premium and bespoke legal service look like? Is it a service that is commoditized, quick, efficient? Is it a service that actually is able to distinguish between market practice precedents and provide something much more human? Is it a bit of both? Does legal tech have more of a role to play to substitute for low-level, menial, expensive parts of our practice, or does it have a role in providing more of the high-level judgments that we would typically command high fees for, have decades of experience in dealing? And I think we've covered and flagged some of those issues today, and now it would be great to open to the floor if anyone has any questions, comments, any experience of these issues, any specific queries for any of the people on the panel here. That would be great. But thank you very much to the panel, and looking forward to hearing any views from the floor. Yes, at the front.
Hello, my name is Liman. AI is certainly a very great opportunity for the world, but as intimated, there appears to be a lot of challenges, and in particularly the developing countries is even more serious because of the digital divide. That is internet connectivity, and more so the literacy level. We are all aware that in legal practice, confidentiality and privacy are very important. So in instances where these challenges come up, it's a bit difficult to have centers or to have people to help. So I think that in developing countries, we have a bigger problem to deal with in that space. For instance, if you look at virtual court system, the stakeholders include the clients or the parties who will have to connect remotely. And because of these challenges, it's practically becoming an impossibility. That said, I think that one critical challenge of AI has to do with the algorithm biases and impartiality. And I've been thinking what we can do to be able to ensure that at least we minimize its impact. Because AI most often is cross-border. And you may have some that may just be built based on certain core values that may not be so relevant to other jurisdictions. So, and I don't think regulation will be enough to be able to handle that. So as experts, what do you think is the best way to handle that? Because I believe that is the key challenge that we need to address. Thank you.
Does anyone on the panel want to address some of the points raised? Hossam.
It's a very interesting question, and I think one of the impact why most of law firm in developing country, as you mentioned, not impacting the AI, is because of the cost effect. The cost is so high to make an AI implemented, plus the protection of it. Because to protect it, it have to make many layers and many concepts which have to be as cybersecurity and the protection, anti-protection from through any attack or any hacks, which will cost a lot of monies. Most of law firms in Middle East don't have that capability to do it, to handle that. That's, I think, one of the reasons why they are not integrated to or depending on AI so much on that days. It's, yes, we as a lawyers, one of the reasons why the client came to expose all his under-table secrets is the confidentiality. And he's certainly sure about he's being protected, whether we like it or not, because it's contract obligation, it's a theoretical application, it's emotional implications. So, but how to implement it, I think it will be sometimes before we reach to that level after it become enforced on us in these countries. That's my idea.
I'd just add one small thing since we're talking about confidentiality a lot, and I'm strictly talking from the point of view of, say, developing countries. I'll talk about India in that context. Like we say that the confidentiality, the client counsel confidentiality is utmost. I think when we talk about integrating AI in terms of drafting documents, in that context, the discretion has to be made by the lawyer or whoever is using the particular tool to draft, to understand to what extent the information and what information has to be fed, so that even if it is in the public sector, it's not something that is breaching the confidentiality. At the end of the day, I think we will have to put pen to the paper when drafting contracts or when drafting any document that is of extreme importance in terms of confidentiality, unless like you said, we have such levels of security and levels of coding that ensures security of the document or the information that the document will hold, which I think is a distant dream for the time being. In any case, with more and more layerings and more protection, there are also more and more skills developed in hacking. So we can never really be absolutely confident about it. So my belief is when it comes down to confidentiality, pen and paper, any day.
Brilliant. I think we probably have time for one more question at the front.
Hi, Hi, I'm Vivek Sareen from India. And I can relate what Ekta is saying because I also practice there in Delhi. So, Ekta, you have raised a very valid point. So, my statement, not even suggestion for your consideration is that probably you can make this proposal to Supreme Court of India to publish the documents of the cases which are disposed of long back and there's no confidentiality. So probably that can be considered through AOR association from Supreme Court. So probably that will help the new guys, the junior guys, to take the benefit of AI, because any which way it can't be stopped, and it has to come and it has to take over, and something will happen probably we don't know. So that is my, just addition to what you're saying, and I can very well relate that. Number two is that in my experience, I have only one time I've used AI, and that too about the classification of AI itself, how to classify for the custom usage and the custom classification and the custom duty import. So I could not get any answer, so we struggled for 5, 6 days, then we have to do it manually. So that's where, in my experience, we were not efficient enough to use it, and we failed. And the third thing, which is to the panelists, that could there be a situation after 5 years down the line, or maybe 10 years down the line, then we will be discussing about that by a social agreement, the AI is going to be an artificial person like a company. And if that be the so, then what will be the landscape of businesses across the globe? Because making somebody artificial person like company is only based on, not from some divine theory, but based on the social contract. All agreed to give it an artificial persona to the company. Similarly, it can also happen to artificial intelligence. Maybe ChatGPT is an artificial intelligence and is an artificial person.
I think that's an interesting one. Farouk, you have just under a minute before we conclude this and get coffee.
I think I'm just following the international court precedents developing on this artificial intelligence and whether the products of artificial intelligence, especially in the case of artistic works, deems worthy of intellectual property protection. I think so far the court's general view is that there will be no intellectual property protection for the works of the AI. I think this will limit what will be produced by the artificial intelligence will not be commoditized, so they will not be the real persons, legal persons or artificial persons replacing the real persons. So because otherwise I think someone may take the benefit of the artificial intelligence, and is the first mover advantage, then they can become the monopoly of this artificial intelligence technology. I think the courts and the legal profession in general, I think, is more pessimistic about giving that opportunity to one company and having one artificial intelligence company providing all services. I think there will be more protection, especially on the benefit of the human works and our own intellectual property. I don't know if it's properly addressed, but it was just under a minute, so thank you.
Brilliant, thank you very much. Thank you to the panelists for your insights and a wide-ranging and interesting discussion. Thank you to the audience for your questions, and we look forward to discussing this further in the break and over the course of today. Thank you very much.
What an exhilarating, technological, and intelligent start to our conference with session 1. But before we venture into the next phase of our program, let's take a moment to express our heartfelt gratitude to the brilliant minds that made session 1 an outstanding success. A huge thanks to our incredible panelists. Once again. Your insights have ignited a spark that will undoubtedly continue to illuminate the path ahead. I request our moderator, Julius, to present the mementos to our esteemed panelists now. Maybe come to the front side. That will make it easier. Yeah. Thank you.
Thank you.